Good evening, all. Shri S.K. Rahman, Honorable Member, GSTAT, Chennai. Shri Mathew Jolly, Honorable Member, GSTAT, Coimbatore. Shri S. Jayakumar, Founder and Country Head, Swami Associates, and also our mentor and GST consultant. My colleagues, members of the chamber and participants, a very good evening to you all. It gives me immense pleasure to extend a warm welcome to our distinguished guest speakers, Shri S. Jayakumar, and all the participants to this important GSTAT awareness and outreach program. I express my sincere gratitude to Shri S.K. Rahman and Shri Mathew Jolly for graciously accepting our invitations and making time to be with us today, despite their demanding official commitments and personal commitments. My special thanks also to Shri S. Jayakumar for his valuable coordination in bringing together our esteemed speakers and for kindly agreeing to moderate today's session. Sir, for information, whenever Jayakumar sir conducts a program here, we have a full house. He's a real rock star and big support to the chamber. The goods and service tax has become an integral part of our nation's economic framework, impacting businesses, industry, professionals, and citizens alike. I'm confident that today's session will be highly informative and beneficial, particularly in the context of the establishment of the GST Appellate Tribunal GSTAT bench at Coimbatore. We sincerely appreciate the government for the significant initiative which will greatly benefit and facilitate taxpayers in resolving their GST-related dispute in a timely and convenient manner. I request all the participants to actively engage with the deliberations, make the most of the expertise of our distinguished speakers, and utilize the interactive session to clarify your doubts and gain valuable insights. With these words, I once again extend a hearty welcome to our esteemed speakers and to each one of you. I wish you all a meaningful and enriching session. Thank you. It's our privilege to honor you all.
One bouquet also.
Yes, yes. I now request Shri Jayakumar sir to introduce the guest speakers.
Good evening, all. The most distinguished dais, my president, vice presidents, my brethren. They say Calcutta is city of joy. There's a saying. I came to Coimbatore accidentally in 2004. And from that moment, for me, Coimbatore is the city of joy, city of peace, city of tranquil, and more than anything else, which made me to migrate from my from where I was born. I'm now 10 years old with you. Coimbatore is a city of soul. This is what I have found. We run offices in 15 states. We run offices in so many places. But I finally found the soul connect is in Coimbatore. I warmly welcome the two great members, Mr. Mathew Jolly and Mr. S.K. Rahman, to the City of Soul. Hereafter, I'll call this the City of Soul. Sir, it takes immense pleasure, privilege, and pride, more than anything, gratitude, to invite you both to this August gathering. Why? Because this was the place actually I was born. My profession was born in Coimbatore, and that too in this long back, way back in 2003. D. Balasundaram, who is my mentor, whom I rate till date as the godfather of my profession, first introduced me in this dais and introduced me to this public. And from that day onwards, this gathering, this chamber has become a part of my family. And when I say it is not words, it is a true emotion. And that is the reason why I chose, in spite of we having multiple offices in multiple places, I was so keen that this outreach and awareness has to happen to my family, to my brethren, to my community. And that's what I went to President and requested that Coimbatore is going to have the GST Appellate Tribunal. This is a very, very important milestone in not only in GST administration, but also for Coimbatore. Because till date, for all our excise and customs and service tax matters, our tribunal was in Chennai. So, for all the cases beyond the first appeal, we were going to Chennai for the tribunal. Now, for once, the mountain has come to the Mohammed. The tribunal has come to Coimbatore. I have to heartily congratulate President and the Chamber. Why? Because bringing a bench here, I know what are all the efforts, because how many representations I have also written in the past so many years. Mr. Natarajan knows. We have made so many representations that there should be a bench in Coimbatore, which got fructified, and now we are having a permanent bench in Coimbatore. This is going to help us in so many, because Coimbatore is an industrial hub of the entire Tamil Nadu. Say, Chennai is the headquarters, Madurai could be we have an additional bench of the High Court. But if you take industry, if you take the economic activity, Coimbatore is a very important hub, and it needs a resolution, dispute resolution. A place in Coimbatore was our theme for the so many years, and that has happened. That has become a reality. Now today, GST Appellate Tribunal is going to be functional, or rather already it is functional, I have to say. Mr. Rahman, the member technical, has already inaugurated, and they have started hearings in Chennai bench, and very soon we'll be having in Coimbatore. Coimbatore, we are going to have near Goldwins, I believe. We'll share you the address. There we are going to have the GST Appellate Tribunal's bench, where Mr. Mathew Jolly, I'll be introducing them. For the first time I'm carrying a paper, because so many they have laurels, I'm not able to recite out of memory. And Mr. Mathew Jolly will be the technical member posted here. He'll be heading this GST 88 Coimbatore. Mr. Rahman will be the technical member who is sitting at Chennai. They both come from an extraordinary laurel, which I'll be trying to, I have made it so concise. In fact, I took the help of ChatGPT for once to reduce it, because so much was the profile, the whole day will be gone. So I asked Vaishnav to say, reduce this profile and give it to me in 10 lines. So for once, I'm using this. Now I'll introduce the distinguished speakers of the day. One, Mr. S.K. Rahman. He's an IRS officer. He joined He's going to be the technical member sitting at Chennai. He's a 1992 batch revenue officer of Indian Revenue Service. He's a graduate from BITS Pilani with over 3 decades of distinguished service in customs, excise, GST, narcotics. He has held several key positions across the country, including Chief Commissioner of CGST, Customs of Trivandrum and Kochi. He was a Joint Secretary of the GST Council. And he has done so many senior leadership roles in tax administration and policy formulations. A recipient of the President's Medal he's a President Award winner. A very, very distinguished medal for the distinguished service. The World Customs Organization Certificate of Merit and the Narcotics Control Bureau DG's Commendation Medal. He is widely recognized for his contributions in indirect taxation. All this apart, I used to always say this, I can't conclude without introducing Mr. Rahman with 2 lines. One, his tenure in Chennai Customs under SVB, we call it a Special Valuation Branch, and the number of orders he has passed is a history on record. He has passed so many orders that it will take another 100 years for any officer to meet it. He is the Messi of our customs. The man with the golden, not with the golden boot, but with the golden brain. And the last line of Mr. Rahman I used to say everywhere, Tamil Nadu is known for 2 Rahmans. He is the other. And his orders are nothing like, they are poetry in motion. We are all going to witness it. And he has a special thanks to him because he had a personal difficulty. His wife was hospitalized. She is yet to be discharged. Still in the hospital. From there, he took time because he has given a word to our chamber. He flew all the way from Chennai. And she is still in Apollos. So, sir, all of us, the entire soul of Coimbatore, will pray for a recovery. And we are very, very happy and emoted for your gesture. Welcome to Chennai, sir. Now we'll come to Mr. Mathew Jolly. He's an IRS officer, retired, and he's a medical doctor by profession. He's an MBBS. We were chatting in the 4th floor. That time he was saying why he did not choose the MBBS as a profession. Touched my heart so much. He said, that is a very intense profession. So intense that if I am going to do a small mistake, the entire, because it is playing with human lives, it will be so depressing for me if I do one single mistake. My mistake should not cause somebody's or families or larger woes. So I chose not to practice that because one mistake, see, in taxes, I was also saying to him, if you do a mistake, then there is an appeal. If there is another mistake, there is a second appeal. He said that in doctor profession, there is no appeal. So I didn't opt for that and I chose IRS. In fact, I would say that is a blessing in disguise for us. That's such a wonderful officer. I have not seen a rooted officer. He will be, he will be feeling awkward when I'm going to, or embarrassed. Even if I'm going to say 1 or 2 extra words about him. Such a rooted officer. A very great human being. In fact, they used to say about Rajinikanth and Kamal Haasan. Kamal Haasan is the greatest actor. Rajinikanth is the greatest human being. Like that, I know Mr. Mathew Jolly personally because I've been in the gallery and watching him. He's one of the greatest human beings. And nothing can be appropriate that a man of this integrity and humanity, who is having humanity in this, is coming to the city of soul. So we are in safe hands. We are we are going to be having a wonderful tenure with such a wonderful officer who is going to don the GST tribunal in Coimbatore. And coming to his accolades, he served in various capacities, starting from an assistant commissioner, a joint and an additional commissioner, commissioner appeals, additional director general in NASIN. NASIN is an institute which teaches the officers. So he was an additional director there, then a principal commissioner in Chennai Customs. He retired as a director general of DGGI, the most dreaded, what to say, the name gives butterflies to us. DGGI. He donned as a director general, and that was the only period I was not having butterflies in my stomach when he was donning, because he was very, very sensible and a template officer of DGGI. In recognition of his extensive experience and expertise in indirect taxation and enforcement, he was appointed as member technical. Now, he's rightly decorated to be the technical member, or the first technical member of the GST. GSTAT is something which we all wanted for years. I have spoken so many times here. Now it is coming after a long wait from 2017. I used to always say that from 2017 we were waiting for it. Every meeting we used to say that there should be we used to give representations we need. Now it has come. Now it has become a reality. And I leave the dais to Mr. SK Rahman, who has come with a presentation to tell you about how this tribunal is going to function, what is our responsibilities, because this is something which we should never ever take very light. Why I'm saying this? See, this is Supreme Court. This is the Supreme Court for GST litigation. Please consider that. After this, you cannot question on facts in any place. You have, after an adjudication, you have a first appeal. After first appeal, this is the second appeal, which is the ultimate final fact-finding authority. After this, there is absolutely no resolution thereafter. There are only 2 points, x-axis, y-axis. One, on the question of facts, this is final. Whatever we have to say, we should say before the tribunal, and the decision will be taken. That is final. Two, if you miss the bus, I think Mr. Rahman will definitely touch upon that. Lordship will definitely touch upon that. Is if you miss the bus, there will not be any remedy available to you. So with this caution, words of caution, I leave the dais to the distinguished Mr. SK Rahman to give a presentation, who has come with a, I think, sir.
Mathew, sir.
Oh, first you will finish it, sir. Fine. Okay, then we'll have our son of the soil now. We'll have Mr. Mathew Jolly to address the gathering, and thereafter Mr. Rahman will take it forward with the intricacies of this. I'll leave it to you, sir.
Thank you, Mr. Jaykumar, for bringing these two distinguished gentlemen here. And it's a privilege to share the stage with these two great personalities.
Dignitaries on the dais, my colleague and friend, Mr. Kadir Rahman, and all the members of the Indian Chamber of Commerce and Industry of the Coimbatore chapter. A good evening to all of you. It is growing up in Kerala, in Cochin, I have always been fascinated by Coimbatore. And there is a reason for that. My father, after he retired from the Navy, he set up a small farm, and the farm required pumps. And right from then, I have been hearing, pump and Coimbatore. You go to Coimbatore, if you want a pump, you go to Coimbatore, and not 90%, almost 100% of pumps manufactured in India are made in Coimbatore. So I always used to wonder, why is Coimbatore such a special place for pumps? But then I realized, as I grew up, I'm talking about the 70s, this was the 70s, and as I grew up moving into the 80s, I started hearing that no, Coimbatore is also specialized for textile machinery. Then as you move further, it's specialized for precision tools, for automotive parts. And then now I hear, I mean, maybe about 5 years back, we started hearing that you're also specialized in aerospace parts. So, I mean, this has really fascinated me over the years. And while I was in, I joined in 1992. Kader and I joined in 1992. And I had always wanted to get posted to Coimbatore, but I could never come here. And finally, after I retired, the government appointed me and posted me to Coimbatore. I was so happy. And I have been here for the past 6 months. And let me tell you, this is the nicest place I've worked. I'm so happy. It's such a lovely place, fabulous infrastructure, lovely weather, people so nice. Everything, everywhere it's a dream place for a person to work. So, I mean, after getting posted to places, I would be so happy to give something in return. I really would like to serve the people of this city and this area, obviously, because the GSTAT Coimbatore has a jurisdiction of 9 districts of northwestern Tamil Nadu. All the appeals which are filed from these districts by taxpayers, GST taxpayers, will be coming to the thing of Coimbatore. Sorry, the Coimbatore bench of GSTAT. So it's such a pleasure for me to be here. Now, when Mr. Jayakumar approached me and said, that we have to, sir, could you have an outreach program out here to explain to the members of this chamber what the appeal procedures are in GSTAT. I mean, I was so happy. I was more than happy. And then we had fixed on, I decided right then, that Coimbatore deserves the best. And the best in India, I can tell you, as far as giving a talk on appeal procedures in GSTAT, is Kader Rahman. He is, finally it was so difficult to get him because he's been running around all over the country giving lectures. Aurangabad, Delhi, Guwahati, wherever you give him a date, immediately he's looking at his calendar, I've got a date there, I have to give a thing there. Now, apparently yesterday, his wife was in hospital. He ran out from the hospital and gave a lecture in, I think, Hindustan Chamber of Commerce, somewhere there in Chennai. So, he is absolutely the best. If he cannot answer your doubts, any doubt which you raise here today, then nobody can. I can only speak, but he can answer your doubts. But nobody can. And if he can't answer, you can trust me, he will note your doubts and he will send me a reply saying that please give us this thing to so and so person. That's what he will do. He's so clued in on this thing. So I decided, okay, that he should come and speak. So then finally, because of his personal problems, the 4th was the earliest day that was possible for him to come. And you know how he's come, this thing. So then we fixed on 4th. Then the last date for filing of appeals was ending on 30th of this thing. So then it became a problem. Now, without his Kader's expertise, people will not be able to, in Coimbatore will not be able to file appeals. So then I made an urgent request to the Ministry of Finance. Please extend it. They asked me why. I said, no, Kader can speak only on the 4th. He can come only on the 4th. So, please. So the moment I said Kader can speak only on the 4th, they said, no, Kader can speak only, then we will extend it. Then we have to we will extend it. So what has happened finally, because he could come only on the 4th, the whole of India has got a reprieve. And they need file only by the 4th. So that is how this thing, how Kader is respected. So that's why we decided this thing into 2 things. Kader, technically competent, he will give you a presentation on on the actual procedure of filing appeals and how these things are heard. Whatever related to appeals, he will tell you. Now, Kader will give you a very theoretical thing, he knows thing. But the man on the ground, that is actual procedures on the ground, is generally handled by the registrar, assistant registrar. So I thought the assistant registrar of Coimbatore also should be here. That is Sanak sitting here. Sanak is here. So the actual procedures regarding filing appeal, those things, suppose you have any doubts about for specific to Coimbatore, because you are all members of Coimbatore, you can always, now after this thing over, you can interact with him, or you can meet him anytime. We have created a help desk, and he is available to you for clearing doubts. When he has a doubt, he will ask me, I will ask Kader. We will get that and we will settle your problem. So that is an assurance which I can give. Now coming to the actual, about GSTAT, just a brief about GSTAT. Kader will speak to you about the appeal procedure. About GSTAT, I will tell you. I will just tell you about Tamil Nadu. There are 2 benches of GSTAT in Tamil Nadu. Normally, benches are created where the high courts are. Okay, so the High Court of Tamil Nadu has of Madras. It's actually called Madras. Has got two things. One is in Chennai and other is in Madurai. So typically the benches would have been created in Chennai and Madurai, but the government was fully aware of the importance of Coimbatore as an industrial location and the number of units that are there here. So they decided that Madurai bench, each bench consists of 4 members, 2 judicial and 2 technical, that 2 members of the Madurai bench will be housed in Coimbatore to mitigate any difficulties which the taxpayers in Coimbatore have. So bench also, so this is created as a part of Madurai bench and 2 members will be sitting here. So I have been posted as a technical member, that is supposed to be the expert member on GST matters, the judicial member. Now, so that normally there should be a judicial member here. Unfortunately, what has happened is, there are 4 technical members and 4 judicial, there are 2 technical members and 2 judicial members in the bench. Now, Tamil Nadu has got 2 benches, so there should be 4 technical members and 4 judicial members. Now, all the 4 technical members have been appointed. 2 members of the central government, that is Kadir and me, and 2 members of the state government, they were appointed last week. So we have all technical members appointed. Judicial members that have been appointed by the central government, only 2 members have been posted, and both of them are posted to Chennai. Unfortunately, one of them got another appointment, he's resigned and gone, which means that there is only 1 judicial member left for the whole of Tamil Nadu out of 4. There are 3 vacancies. So there is 1 vacancy in Coimbatore, there's 1 vacancy in Madurai, and there's 1 vacancy in Chennai. Now, a bench hearing a case, Kadir will explain, hearing a case of more than 50 lakhs has to consist of 2 members. That should be 1 judicial member, 1 technical member. So, to hear cases more than 50 lakhs, we will have to get the judicial member from Chennai to actually be with me to hear the case. And knowing that this problem is there, the president of GSTAT has already decided that the 2-member bench will convene on Thursdays here. Once the hearing starts, they will convene on Thursdays. The division bench will, wherever 2 members are required, they will be hearing cases on Thursdays. On the other days, I alone will hear the cases which are below 50 lakhs with no question of law. I can hear the remaining days. Okay, so that is the plan. So I am telling you this because of the lack of judicial members, there may be a slight delay in hearing your appeals. But I promise that we will do our best under the circumstances possible to try to give everybody a hearing as soon as possible, because we are fully aware that you have paid your pre-deposit, your money is at stake, your case is at stake, and then you require a reasonable and fair outcome as soon as possible. We are fully aware of that, and that I can assure you we will do that. Now, I was checking the appeal status today, as of today. Yesterday, I think we checked yesterday, there were 369 appeals filed, right? 369 appeals filed. So I am a little surprised, because I would expect that I would have thought that there would be more appeals being filed here. But so far I have only 300 appeals filed. I don't know whether it is because the notification extending the date came on 29th, so people who are waiting for the last day did not file. But I will hope that the number of appeals is low, because what would that indicate? A low number of appeals would indicate that the original authorities or the appellate authorities are doing their job well. Okay, and that there is, if they are doing their job well, there is no person who's happier than me, because obviously it means that you have received justice earlier without coming to tribunal itself. But I don't know. I really don't know how many. That only what the future holds. I don't know how many appeals get filed in the next month. But if it is low, then I will really rest happy. Not only because it reduces the work of the bench, but also it has ensured that the original authorities and the appellate authorities have done a good job, and you have already received justice. I hope that is the case. Anyway, whatever it is, we will, whatever appeals come, as I said, there will be initial teething difficulties, because the Coimbatore bench is supposed to have a staff of 14 and total, including 2 members and everything, and only 2 people have been posted so far, just Sir and me. Now a third person, since we were not getting sufficient people from the department, a third person, a retired hand has been recruited. He is joined yesterday. So he'll be the court master. So then now it has gone to 3. So once we get at least 2 more people, I can really try to go the whole hog. But till such time, there are certain constraints. Our infrastructure is getting ready. By the end of this month, we will be ready to move into the permanent building. That is near Goldwyn's Junction. Okay, it's just off the airport runway actually. A nice building which is more than convenient. It's got adequate facilities for everybody, for the staff, for the representatives who come. Everybody is adequately done, and they will feel no problem on account of lack of facilities in that place. That much I know. Now the only hurdle which right now I'm facing is, I told you, 2 things: the lack of staff and the lack of members. But we will try. I mean, I personally will try to ensure that whatever cases are listed, we try to finish off as soon as possible. So in that endeavor, I will also require the help of the authorized of the industry. In that, once an appeal is filed, please don't keep asking for adjournments. Please make sure that your representatives, whomever you have authorized, please ensure that they come in on the day which the case is listed, and the law itself mandates that you cannot give more than 3 adjournments. Okay, so if as far as possible, try to come on the first day so that we will not have to post the case for another day. So that I would make an ardent request to the fraternity. Please try to make sure that your authorized representatives, because when you put pressure on the representatives, no, you have to attend, then they will come. Otherwise, they might seek an adjournment. So as far as possible, try to ensure that people come on the first day of hearing itself so that we can hear it and try to finish it off as soon as possible. See, as it is, the tribunal is short staffed. So if we are forced to give more and more hearings, one hearing means one person who's down the list, his justice getting delayed. So we really don't want that. So try to make sure that your representatives represent you on the listed date. So with these words, I just have these things to say. The rest of it, Kadir will tell you, what the procedures are. He will tell you that is what actually we are supposed to do. Sanak, if you have doubts, you can ask him. What on the ground, what is the stage now? We have actually created a help desk. We have issued a public notice. Sanak is one of the persons whose number is listed there. You can call him. You can feel free to call me anytime, any doubts you have. We are only glad to help. Okay, so now I will stop now, and I really do hope that now that the GSTAT will be functional, interesting by next month, that we, the bench, will be able to give a fair finality to your appeals, and at least you will know, okay, what is the legal position of the dispute that you have. We will try to ensure that. Of course, the appeal from the GSTAT will lie to the High Court. For most things, it's only for High Court. All are High Court. Everything. There's nothing that goes to the Supreme Court.
No. Only principal bench.
All go to the Supreme Court. So everything will be to the High Court. So the appeal from the GSTAT will be to the High Court of Madras. Will it be Madurai or Madras? It will be Madras.
Sir, we have both, because GSTAT comprises of both Madurai jurisdiction also we have.
Okay.
And Chennai jurisdiction also we have.
So that will depend on where the assessee is located. So the rest of the thing, Kadir will
bench of
be
Madras High Court.
So with these words, I will conclude, and I wish all the entrepreneurs of Coimbatore. I know Coimbatore is a city of entrepreneurs. I wish all the entrepreneurs of Coimbatore success in their ventures. I know that the ability is there, and you guys are the best in India. Because, Coimbatore with a population of 35 lakhs, 32 lakhs or something, has the second biggest MSME contribution in India. Imagine just the second biggest from a population of just 32 lakhs. You can imagine what a great contribution Coimbatore is doing to the country. It's just incredible. And I wish you success. I wish all of you success in whatever endeavors you may have. Good luck to you all. Thank you very much. Jai Hind.
Excellent speech. Get motivated. Let me shake hand with you. I get motivated.
You can leave the dice too.
I request Rahman sir to address.
When I do PPT, you will not be able to see. No? When I start PPT, it will be more convenient for you. You will not be able to see backside. That's what you have here. Okay, okay. Dear brother member Mathew Jolly, Shri Rajesh B. Lund, President of Indian Chamber of Commerce and Industry, Coimbatore, Shri S. Jaikumar, Swami Associates, and Shri N. Pradeep, Honorable Secretary of Indian Chamber of Commerce and Industry, the other office bearers of this chamber, members of this chamber, and various professionals, industrialists, service providers of Coimbatore. Very good evening to all of you. Coimbatore is not new to me. My first posting was in Tuticorin in 94 to 96. So I came here in 95 onwards once. And also when ACS was launched, there was a lot of training that was being conducted from Coimbatore. And 2017, my third visit was when GST was launched. I came here again for having various meetings. That way, Coimbatore, even though Mr. Jaikumar calls it city of soul, what I learned and what I call it as city of, I say capital of, intellectual capital of Tamil Nadu. Political capital may be Chennai, but I feel the intellectual level, the maturity of the people here, and the sophistication that I am seeing at Coimbatore, you won't get it at either at Chennai or any other place. With those few words, without wasting time, let's get on to the business. So today, as you know, as Mr. Mathew Jolly has also mentioned, the hour of the need is actually to file appeals. How much ever appeals that are pending with you, which you want to go in appeal. It's not that it's compulsory, which you want to go in appeal, might as well file, because the last date is fast approaching. It is 31st July for the orders that you have been communicated to you up to, let's say, 1st May. 1st May and later, obviously, the 3 months period that will start. Considering the importance, this is very, very right time that it has been planned to be conducted at Coimbatore. And it is also right chamber that Indian Chamber is hosting this. That's a really great thing. I mean, I really want to thank the Indian Chambers and Coimbatore people for having this kind of discussion at a crucial time when GSTAT is just about to take off. It is just taking, its footsteps now. This is the right time that we are discussing about it. What I plan to do is I'll run through the presentation I have prepared on this particular topic to show it to you that GSTAT is, is the right forum for expecting a justice after, your original adjudication and after your, first stage appeal. And considering that I have divided my presentation into 4 parts so that it serves to different sections of the people who are attending, or otherwise also Chamber of Commerce as well as professionals, industrialists of Coimbatore, is that first part I would like to cover on the portion about GSTAT. What is the structure? How do we go about it? How do we handle the appeals there? What are the basic prerequisites about GSTAT? Second portion I would like to cover is about what are the common mistakes that are happening. Joint assistant registrar, joint registrar here, Mathew Jolly is also here. They will also join me. And this presentation is common presentation from Coimbatore and Chennai. This for entire Tamil Nadu. So they will join me to say what are the common mistakes that are happening, common defects which can be corrected when you file, how to file a defect-free appeal. Third portion I want to tell was very important portion is that till now there's an impression that only advocates can appear in high courts and other thing. But tribunal is one place where professionals can appear, chartered accountants can appear, industrialists can appear, employees can appear. So it's a great opportunity that has opened up. So how do we handle the court craft? How do we handle the cases? There are just a few glimpses. And the last portion which I want to cover is about, what are the best practices that all of us can adopt at the great institution called GSTAT to make it a really successful institution. This is how I'm going. I hope the pattern is all right for you. So to start with the first portion about GSTAT, that also I have divided into, I have divided into 10 subsections, where I would cover about, let us say, about what is GSTAT, how we go about it, what is principal bench, what is state bench, what is single member bench, what is divisional bench, and what is the importance of GSTAT, and how does the portal operate. So to start with, first one I wanted to mention is about the length and breadth of GSTAT. As you have seen, GSTAT is available, unlike other tribunals, unlike particularly other indirect tax tribunals at selected places. GSTAT is available at 31 states, that is 28 states and 3 union territories with legislature. And it is available at different 45 locations all over India. And it has started practically, the portal has started practically working from 25th of September 2025. It's almost more than 9 months now. Now, if you see, as it has been mentioned to you also, principal bench is located at Delhi, and principal bench consists of 4 people. One is the president, who is a judicial member, another judicial member, 2 technical members there. Every state bench at the 31 locations, every state bench at 31 locations, 31 states, is that there will be 4 members in a bench. That is 2 judicial members and 2 technical members. Tamil Nadu is blessed with 2 benches. Each bench means 4 people. That means Tamil Nadu is blessed with 8 people. But remember that we may come from member technical center, or somebody can come from member technical state. Want to sit up on the bench, it doesn't matter whether you are at center or state, because when the cause list keeps coming up, the cases which come up may come up cases which have been investigated adjudication by state. We may come up the cases which have been investigated adjudicated by center. It doesn't matter. It doesn't matter. When the case comes up, the bench hears, irrespective of the member is from center or state, and the authorized representative, departmental representative of the state government will appear if it's a state case, and central government will appear if it's a central case. I hope that clarity is there for you. Now, this is what you can see all over India, how it is spread out. You can see at various places it is spread out. There are around 45 locations. There are 24 regular benches. Regular bench means Chennai is a regular bench. A sitting bench like Madurai, Coimbatore and Madurai is a sitting bench here. Then there are around 3 circuit benches. For example, Pondicherry, if you see, entire Chennai bench will go and sit in Pondicherry and operate that. It goes upon 4th and 5th Friday of every month. Now, if you see here, I am showing you a map. I don't know how clear is that. This is the north portion which is covering the Chennai bench. There is a notification that is issued. According to this notification, north is Chennai bench. Then the southern Tamil Nadu is Madurai bench. And then this northwest portion is Coimbatore bench. Here there are, I have mentioned it to you, one member judicial who is also called vice president for administrative purposes is there. Member technical center is there. Member technical state is there at Chennai. Then we have member technical center at Coimbatore, member technical state at Madurai. This is what is the present location, and the hearing schedules are like this. If you carefully see them, let's say about this is the present setup. On Monday and Tuesday, we are operating the cases at Chennai. That is, there is a judicial member at Chennai, and myself, we sit on Monday and Tuesday continuously hear the cases. We again have internal division called category 1, category 2. Don't bother about it. Certain categories we are hearing on Monday and Tuesday, and on Wednesday, judicial member and Mathew Jolly will hear Chennai cases of a particular category for Chennai. So Chennai you get Monday, Tuesday and Wednesday. On Thursday, the judicial member and Mr. Mathew Jolly will sit and hear Coimbatore cases. This is exclusively for Coimbatore case. All categories of Coimbatore cases are heard. On Fridays, that is first, second and third Fridays, myself and judicial member will sit and hear Madurai cases. We will go to Madurai and hear the Madurai cases. On 4th and 5th Friday, it's a circuit bench case. So we will, myself and judicial member will go to Pondicherry and hear Pondicherry cases whenever they are listed. This is the present setup. But a good development is that there are 2 state, technical members who have joined. One technical member is posted at Chennai, and another technical member is posted at Madurai. So order is not issued, but order would be something like this. Monday and Tuesday, most probably myself and judicial member will hear the cases at Chennai for Chennai case, bench cases. Wednesday, most probably state member technical will sit with judicial and hear the cases of Chennai. And the Wednesday is anyway reserved for Coimbatore. Coimbatore cases will be heard, and Thursday is reserved for Thursday is reserved for Coimbatore, and Friday, as usual, it is reserved for Madurai and as well as Pondicherry. In Madurai, instead of me, most probably the member technical state who is sitting there will hear the cases. And Friday, because circuit bench, Pondicherry circuit bench, myself and judicial member will go. This order is not yet issued. I have shown in red. I have no authority to issue any such order. I am just trying to indicate to you that there are 4 technical members already available, 4 out of 4. And out of the 4 judicial members, there is only 1 judicial member as on date. So to that extent, we have to adjust. Now coming to the main point about Indian Chamber of Commerce, I know it is members are industrialists. You are mainly manufacturers you are having here. Some service providers would be there. They generally apprehension saying that, look, it's too technical GST, let's leave it to a professional advocate or let's leave it to a chartered accountant. I do agree, you can leave it to them, but at the same time, it's not as complicated as people think of. So my request and appeal and to you is that try to understand little bit of GST by reading few provisions. For your sake, for Indian Chamber's sake, I have brought few sections of GST. Just you can read once. It's not very complicated to understand. I have brought you few rules only, few set of rules which you can easily read and understand from the CGST rules, and also GSTAT procedure rules. One should understand what are the procedure rules I have brought. I have also brought about certain forms you require to fill up, like income tax return you file. Even though you are CA files, you see the form, right? So just have a look at these forms which I have brought. So these forms alone, you can just little bit get familiarized to understand how appeals are filed. And I have also brought few board circulars, relevant board circulars and relevant notifications only. They are simple things. If possible, just try to have a look, because this is the basic knowledge input that you require. Now coming to the importance of GSTAT. Now it's been mentioned also, Mr. Jaykumar has also mentioned, is that please understand that GSTAT is the final fact-finding authority. Believe me. And believe me, your cases which you are going to fight, especially if you are aggrieved of the first appellate order, you are going to play upon facts only. Facts, facts and facts. And this is the final fact-finding authority. After the order comes GSTAT, why I am telling is that to make you feel how important it is that the process that you are handling at GSTAT, don't take it casual. And these facts which you are going to present before GSTAT, beyond this, you can go to High Court, you can go to Supreme Court, but you can't bring a new facts. For fact finding, this is the final. You can only go to High Court as well as Supreme Court on substantial question of law. It is not even question of law, on substantive question of law only you can go. So the importance of it is that as per section 119, if you get an order from GSTAT, if you are filing an appeal also, the section is saying that the due amount due to the government will be realized, irrespective of the fact that you have filed an appeal. It said amount, it didn't say tax. That means your tax, your interest, penalty, fine, everything can be realized by the department, irrespective of the fact that you have filed an appeal in High Court or you have filed an appeal in Supreme Court. Unless otherwise you get a stay. That is the importance of a GSTAT order. Now, this is from the taxpayer point of view. From the departmental point of view also I want to say, so that you can understand your rights. Suppose you get an order at first appellate authority, let us say in favor of taxpayer. Suppose department is aggrieved, it goes in appeal to GSTAT. So the first question that we'll ask to them is, 1, have you refunded the pre-deposit? You pay 10% pre-deposit. So first thing, have you refunded? 2, we will ask the department, have you implemented the first appeal order? Sir, no two persons can think alike. Can you think? Both of you, can you think alike? You can't. There's bound to be divergent practice. That's going to be a big challenge for us. There's going to be, main thing is that knowledge deficiency. For that is what your Indian Chamber of Commerce is doing. That is capacity building. I have done for Bits Pilania. What is your slogan? Knowledge, Gnanam Parambalam. Knowledge is power. The person who has knowledge is the most powerful person. So that capacity building is another challenge that we are having. So considering this, my conclusion of part 3 is that we have to have a way forward. For that way, what is the necessity for me and Mr. Jali Mathew to come and talk to you? I mean, we could have said that. In fact, one of the persons commented, why these members are going and conducting outreach program? There must be something wrong with them. What is wrong with me? I am coming to you to have a good trust-based system where I can tell you to have a collaborative approach, right? There's no necessity for me to come here. But I want to come to you so that you have confidence in me and I have confidence in you. So both have a kind of, these are the 4 principles which I rely upon. One is collaborative approach. Other one is that substantial justice. Please don't think saying that we give an order and say that, okay, now order is over. We are not going to dispose. It's not files. There is no time limit for a judge to dispose the order. I can take my time, but ensure saying that justice is rendered. You may like it or not, you may go in appeal, that's a different matter. But I had to ensure a reasonable order is given. I had to also mention saying that there should be certain amount of predictability and certainty. One nation, one tax, one forum for uniform certainty. Uniformity and certainty has to be there. So that's about my part 3. Anything on part 3 or should I proceed to part 4? Where time is also running.
So should all the papers filed in the bill sign?
I'll come to the question answer session. Just reserve that. Just any feedback on that so that I correct it on part. Every time I recheck so that am I doing right or not. Now come to the part 4. Quickly I'll favor, then I'll take empty number of questions. Absolutely no issue. Now comes to the part 4. Part 4 is our dream. APJ Kalam also said, saying the first you should have a dream, then you should convert your dream into action points, then you implement that, correct? So unless we have a dream, both of us are not going to achieve what we want to achieve. What is our aim? What is our aim of GSTAT? Basically, me and Mathew and Shri is here, is to instill confidence upon you that we are going to have strong appellate mechanism which will render justice. So this is our aim. Our president has said, on the day of inauguration, GSTAT full form he has given. He said G stands for growth, S stands for speed, transparency, accountability, technology driven. This is a statement given by our Honorable President. And in fact, Revenue Secretary on the day of inauguration also said the 3 S. What are the 3 S? One is that scale at which we are operating. One is the spread that we are having. 3 is that synergy that we are having between judicial and technical. Synergy we are having man and the technology. So with that, our aim is that to give you a strong appellate mechanism. How do we want to do it? I am proposing 6 subject to acceptance of individual members. Mr. Mathew Jolly may adopt his own methods. I may adopt my own methods. My judicial member adopt. My aim is that by following these 6, we will be able to quickly dispose and give you justice. Number 1 is a single member bench. As Mr. Mathew Jolly also mentioned, if you want less than 50 lakhs cases and where question of law involved, parallelly we can sit and start disposing. By disposing means again by hearing cases, all those. 2 is that bunching of the case. If one notice is there, notice 1, notice 2, notice 3. No, all the 3 might have gone in appeal or not. Commissioner appeal might have given. Commissioner appeal means joint commissioner appeal or commission might have given an order separately or combined order with appeal numbers from 1 to 3. So we will try to merge all the 3 appeals or 4 5 appeals pertaining to particular show cause notice order individual. Similarly, we will try to merge for a particular taxpayer. Merge means bunch per taxpayer for different tax periods. We will try to also bring in, suppose one particular issue is involved, even though different taxpayers are filed, we will try to bunch the case, and here in sequence. Bunch the cases means appeal, first counsel appears, then second counsel same, no, so okay, we will not say no. Give audience to him, give audience to second counsel also. Let him say what he wants to say. Give audience to third counsel. Afterwards, then we'll say departmental representative, bhai, what do you want to say against this? He will say again, first counsel is this, again, second counsel is this, third counsel is here properly. In GSTAT, my experience is that 1600 cases of undervaluation of aluminum scrap were heard by principal bench by listing them together for almost 5-6 days, and combinedly one order is passed, including the appeal numbers is 1 to 1600, but combining all of them, they have passed order. And believe me, I learnt a lot from the Honorable President of GSTAT that he had so much patience to hear each and every appellant, each and every respondent. I was respondent for each and every appellant. He said, Rahman, say about this, Rahman, say about this, Rahman, say about this. So like that one has to hear, and we would like to hear that and ensure saying that bunching is done, not at the cost of rendering justice. And next principle we want to follow is about covered cases. There are matters are settled. If certain matter is settled, what is the point waiting further? It's attained its finality. Quote that, and how many cases are covered under the case, you quickly dispose. Unless otherwise the council says that I do not get covered under covered case, then we'll tell him, please convince us. Convince us that how you are not covered by this covered case. He convinces us, fine, we will agree with him. Otherwise, we'll say it's covered case and pass and simple order. Madras High Court are bonding upon me. Other High Court orders also are having effect upon me. So accordingly, we will try to pass orders as much as possible. And second, another principle which I am thinking is that to take up the big ticket cases first. Huge revenue involved. One is quality of the counsels will be very high, and other one is that will become a case law for many of the cases to follow. Let's say if I take up high revenue cases first, and high revenue cases sets a standard where a particular issue, all aspects are considered, and that aspect, next appeals may come part of that. It will be subset of that first appeal. So I can say this issue is already covered in so and so case. passed by us only. In paragraph so and so this issue are discussed. Accordingly, we are also deciding this issue. I cannot give divergent orders, no, provided facts are different. And last one which I want to say is that when I am listing the cases by bunching or any other method, obviously I will be doing not in the sequence. We will be doing not in the sequence. 2017, sir, 24 September I have filed. I have filed in December. First early appeal filed in Chennai was December 2025. So is it compulsory for me to first list that then come here? Rule says yes. But when I'm doing bunching, you will have to also understand and cooperate with us, saying that even though they are filed later, they have been bunched. That is where bench and bar cooperation happens. We are proposing to have regular meetings with the bar, so that bar is not taken for surprise all that. And my principle to this is that there are certain tribunals which have existed for 42 years. There are some good practices that are adopted in those tribunals. I'm not telling you import bad practices. At least good practices that are adopted in tribunal like GSTAT can always be brought here. What are they? 6 principles again. One is that, I need not repeat in detail because your clock is already reaching 6. One is that officer of the court first. I mentioned to you. You are an officer of court as long as you are appearing there. 2 is that strategic concessions. You should know which grounds to stress upon, which ground not to test upon. Focused argumentation. Then the fourth one is a synopsis. Synopsis is very, very useful, I am telling you. When you are arguing the case, before the argument start, first day of the argument itself, kindly give your written synopsis. Your appeal memorandum may be having 10 grounds, A, B, C, D, F, G, H, I, J, K, L, anything it may be having. It will be a bulky document. Don't worry. But see gist of what you are going to argue, in which order you are going to argue, and which grounds are you going to stress upon. Advantages are 2. One is the bench will know, oh, this is a sequence Mr. J. Kumar is going to argue, so that they can predict and say, saying that, okay, fine, it will enter into the brain of the judge. 2, sir, the greatest advantage is that these people will copy and paste your findings. You'll say first para will say facts, second para will say the counsel for the appellant has appeared, has submitted the following. What following you will submit it? Whatever your written synopsis, copy and paste. Advantage is that even if the order comes against you, when you go and appeal to the High Court, you can say, my lord, I raised this point. You see in the para 2, I have mentioned this point. Even then, the bench has ignored this, bench has not countered this, bench has erred in wrongly interpreting by this. That advantage you get. So kindly ensure saying that you follow to give. And I have mentioned already with the honesty you have to follow. I have also mentioned with respect to tag advocates. This is especially for advocates, because when we are working there in GSTAT, we have started one new software called EARC, that is Electronic Authorized Representative Case Management System. That was an app developed on laptop as well as our mobile, which will tell us about which cases are coming, what date, how do we prepare about the cases and go about it. This was basically for departmental representative. I know advocates are here, high IT people, Coimbatore being a very, very IT savvy, city, you will be having, but still a piece of advice is that, you have a database of your clients within your advocate, within your professional, whatever you are advocate or, CA or all thing. So that what you can do is you can list about category A cases, which are those cases which are right now are coming for hearing. Category B cases, those which have already listed, but they are not filed, but they are not coming up for hearing as on date. Category are the cases where bench has already decided, remove them, keep them away. If you club all of them, you get confused. I mean, this is small things I am telling. Defect and litigation management, adjournment discipline. Mr. Mathew has already mentioned. What is the fun in asking for adjournment for the sake of adjournment? It's not going to benefit you, it's not going to benefit bench. Mostly it is going to damage your client. You may impress upon your claimant by claiming a time, but it's not going to help him at all. 1 adjournment, 2 adjournment, 3 adjournments. It's very difficult. Benches are impatient. They have joined the temple. It is like, temple is still under construction. God is not ready, but priest has already come. From September 2025 onwards, our people are impatiently waiting. When will you file appeal? When will I decide? Now you go and ask him, sir, I want adjournment. What will judge say? He'll break your head. He say, what adjournment are you talking? From 24 September, 9 months in, 9 months, what doesn't happen in this world? You know very well. 9 months are sufficient for a lot of things. 9 months is more from the time I started. You are on 30th Jan, you are telling I don't have time to file an appeal. I mean, it's not going to help any one of us. I thought I'll just list it to you, saying that certain things are there which you can always use. And documented files, I did not teach you. I'm not too, a big person to tell you, but one has to have a proper documentation, proper. I have seen that. I have learnt. My first posting was in Chennai. I know my seniors have taught me how to maintain a diary, how to maintain, meticulousness, what people call. So that is very much apparent in South India, particularly in Tamil Nadu. I did not tell you, but this is something, a document file management which I have got. I have only to say certain wisdom that has matured in a particular tribunal. Good practice can be brought here. Those people who have argued the cases, those people who have done cases before other indirect tax tribunals will be the few steps forward when compared to others. So I want the industrialists, service providers, manufacturers of Coimbatore Indian Chamber of Commerce to realize this and saying that if this good practice, because it said wise man learn by others' mistake. So let the wisdom prevail. We are win or lose case is different matter, but let us ensure saying that we go on a right path. And the last concluding note is 6 o'clock. Last concluding note is that, look, yes, Mr. Jaykumar has already mentioned, I mentioned it at other forums also. We are at very critical stage after completing 9 years of GST. GST is the biggest tax reform that has come in indirect taxes after independence. The success or failure of this is going to be decided by whom? By the tribunals. The law aspects are going to be questioned for the first time in the tribunal. Question of law is going to be questioned here. The success or the layering or the way GST is going to transform is going to be shaped now. That is called emerging jurisprudence of GST. That's going to happen now. Now, at this hour of need, is it necessary that you and me quarrel? What I'm trying is that you rise up to the standards of ethical or higher standard. We also rise. We come 2 steps forward to you. You come 3 steps forward to us. We shake hand each other. We will try to make the GSTAT a successful institutions. I have resigned and come here, hoping to do something here. If you tell me saying that Rahman, you don't work, sleep for another 9 months, so that's not proper, no. So what we are coming forward to tell you is that you have to also rise few steps and leave certain things which are maybe could be small thing. Criticizing is very easy, but doing a job is. Auditing is very easy, but doing original work is very difficult. So I am appealing to you through this forum of Indian Chamber of Commerce in the presence of esteemed honorable member of Coimbatore to saying that let us rise up to the occasion to make this GSTAT a successful one. It should not be just like another rung of appeal. So what? I will lose here, I will go to High Court. Everybody says this. What if happen? The bench is the mad fellow, they will give orders like this only, we will go in appeal. Why? At what cost? 100 rupees is involved. If I lose the case in GSTAT, department, I will go in appeal, you are telling. If I win the case, department will go in appeal. So where is the end? 100 rupees you're going to fight for 20 years. What is the cost involved? Bombay people, how do they think? They think 2 things, whether to file an appeal, whether it is going to be financially benefit to me, whether it's going to become a case law which will help me other way or not. This is the aspect that they calculate and file an appeal. So here also I'm telling to you, my appealing to you through this chamber is that let us cooperate each other. Let us try to do some, good, effective adjudication, effective appeal mechanism so that who is our customer? Taxpayer. Who is our customer? Mr. Rajesh Lund. Who is our customer? Your member of council. So the justice should reach it. Nothing is going to happen to me whether I pass an order or not, I get my job. Nothing is going to happen to the council whether you win or lose. But who is be losing in the process? So at least for God's sake, for the benefit of the taxpayer, let us join together, let us cooperate together to make an institution a great success. And I really appeal to you to cooperate each other and make it a good practice. And thank you for giving me patient hearing. Sorry for exceeding time.
There's an English word called overwhelmed, and there is one called flabbergasted. You are flabbergasted, sir. It is as good as a 3-day program. See, the amount of food you have given for thought, which has to be chewed and which has to be, I am known for my speed, but you have beat me by miles. Fantastic, amazing, the dedication, your integrity, your patriotism, all are well appreciated. I'll just conclude because the time is also running out. Sir, coming to the very important points what you raised, I'll start with Mr. Mathew Jolly. He said, please don't take adjournments. Sir, I started my profession, I used to take adjournments because I never had cases. So many times I wanted to go to the court and I was taking adjournments. That was the first year. Now, if somebody is coming to us for adjournments, we are not taking the cases at all. So trust us, representing one of our leading organization, I assure you that from the legal fraternity, there will not be adjournments. Rather, there will be requests for early hearings. We'll give you in a spot, we'll put you in a spot, sir, that we'll be requesting frequent early hearings. And in that only, I just wanted to differ from Mr. Rahman's point. He had a wonderful point on the quantity or the amount involved, if it is going to be huge. That is a practice, standing practice in tribunals everywhere. Say every tribunal, every bench used to have their own x-axis, y-axis. They will say the timeline as one axis, x-axis will be the amount involved. But I request only two things. One is, the issues involved can also be considered. The multiple issues, as Lordship rightly said, that number of issues, if it can be settled in one case, it can be mirrored in other cases. So the number, instead of the amount involved, also have the metric as the number of complicated issues involved will be one. And representing my family, the Coimbatore, we are from an MSME city where even smallest refunds are going to hit our bank. It's very important for us. So please give an early hearing or a concession on the timeline for the refund issues, because that is already killing our capital for the past 9 years. We are coming to you after 9 years. We are coming to you with a backlog of some refunds which are pending for so. It could be 1 lakh, it could be 10 lakhs, or it could be crores. But still, refund is a refund, and that money when we are entitled and it is denied. So please consider our refunds, appeals on refunds also on priority. That would be one request from my fraternity. And this 129 cases. Sir, I have to tell you that I operate in various states, and these 129 cases, the lorry, the check post, instead of check post, we have every road corner as a check post, is what I used to say, where 200% has been paid and has been released for a PIN code number differentials, for all these things. People have suffered, and that is something like customs. The difference between customs and excise was always that customs, we used to pay and fight. Why? Because it was held. Whereas in excise, we used to fight and then pay. Likewise, what has happened is 129 cases are all because the lorries or the vehicles were stopped. We were forced to pay because of the demurrage, because of the urgency. So many cases, nearly I would say 99% of the cases on 129 was never fought at that point. It was always paid and then we have appealed. Which means, and for very, very small mistakes, which Lordship will be seeing when the appeals are going to come. So please, 129 appeals also, even though it could be small, because 200% of the amount has already been deposited. Please consider that also for not only in Coimbatore, but in Chennai also. I would request Lordship to take this as a valid point. The last on the early hearing points would be that there is a scheme. Of course, this law is very wonderful where almost all cases are given under 74. But there is a possibility of a conversion to 73 if the tribunal of any appellate authority deems it fit, that there is no suppression of act, that there is no element which to invoke 74. It can be brought into 73 is something which is inbuilt in the statute itself, which is a blessing. Now, what has happened is, most of the, I would say, till date we have been fighting in original adjudication, appeals, or even advanced ruling authorities, where the confidence, what Lordship was saying about the confidence is not that bright. I have to be very honest. It was almost revenue, I would say it is erring on the revenue side. That is what is our general feeling. Now, the first, as rightly pointed out, the first forum, the first ray of hope, the first light at the end of the tunnel is going to be GSTAT. Because, rightly said, GSTAT is an example which came in 1982, which has become a stupendous success only because of its first forum without any partiality. As Lordship rightly said, he will see the trade as well as the department in the same width, breadth and width. That is something which is going to make this institution a glorious institution. That is the confidence we also have. We are also stepping. Now, this 73 to 74, why I'm harping is, there was an intentional amnesty scheme which came to GST for the first 3 years where there were so many confusions. See, GST came and everybody was learning. Even today we are learning. So this 73 to 74, on those first formative years, we are talking about the nascent years of say 17, 18, 18, 19 and 19, 20. Government department or the revenue came with the amnesty scheme where 73 were allowed to be settled without an interest and penalty. Pay the tax. So many people were interested. But unfortunately, they were all saddled with the 74 notice. And they were all waiting right now. And that this is also very important. This 73 to 74 conversion will help us. Why? Because that amnesty came with a sunset date. But it also has given an open window that once if it is converted into 73, you have a timeline of say 6 months or something, I don't know exactly. 3 months, 6 months. So for us to go and settle.
Suppose it's filed as 74.
Yes.
During the hearing, it is.
If it is held as 73,
So first question you should argue before the.
Exactly.
That, my lord, even the issue of notice under 74 itself is not justified this. First, let the bench first decide about that particular aspect.
Exactly.
Is it 74 or not? Once it concludes that, let us say it is not 74, then easily they can give an order. They can be prioritized rather than waiting for.
absolutely. This is one of my very important requests. That yes. So our even from my fraternity, when we represent, as rightly pointed out, Lordship, we'll argue that it will not be a 73, so that an opportunity for us to take a dispute will be immediately settled. 73 means there may be hordes of people who will be willing to, because there is no interest, there is no penalty, and we are talking about interest at 18% from 17 to today is as good as 200%. So when that is going to be a very killing incentive for us.
Okay, but. Now it is ruled that it is 73 cases.
Three.
Then you can go into.
I can go to the amnesty. I can go to the amnesty.
Now
also I can go. That is what I said. The scheme has come with the open window. From the date it is held as 73, I have a 3 months window to go and pay the dues under 73, settle it, and get out of the interest or penalty. So this is something I want Lordship to take cognizance of. That amnesty has, though it has a sunset, it also has an open window. Whenever that is getting converted into 73, I can always offer this, which is going to be of an immense help to people who doesn't want litigation.
Suppose the respondent, let's say department, counters it by filing an appeal saying that the bench has wrongly concluded that 73 is.
Sir, I will go to 73, settle it, but if court overturns, this scheme may go off. But at least that point of time I am entitled, I will subject myself to 73, pay the tax and get... and so much of disputes are waiting only for 73 and 74 disputes.
Many cases will be there. I will add it to
So many cases, sir, I have to tell you, as a representative, I am telling you. So that is one thing I want Lordship to consider as an early hearing. In the early hearing bandwidth, Lordship said amount, yes, true. Because the amount of pre-deposit is 20%. Say 100 crores, 20 crores I would have paid. That is a huge impact for me. But beyond that, multiple issues could be one. 73 to 74 could be one. 129 because of the 200% I paid is one. And maybe this refunds for my fraternity, for my community is going to be one. And Lordship rightly said that the department is bound to give the money back once we succeed. Lordship reiterated it, bound and bound. I'm so happy, and if the department is going to resonate that integrity, that is going to instill confidence in us that once we succeed or something, immediately if they are going to refund us back. Now, without that contempt possibility, there is a difficulty for us that if it is not adhered, how to come. But we'll iron it out. We have lived with it.
There is a section 115.
Yes.
Clearly saying, 115 section if you read, clearly says that the day you win the case, you file an, in fact, department is supposed to sumo. You file an application to them, not regular refund application, simple application to them. They are bound to, by letter, they are bound to refund to you from the date of deposit to the date of refund. With interest.
6%.
Rate may be 6%.
6% interest.
But interest you will get back. So many people were not filing appeal because their money will be locked up is not really a good argument. Saying that, hey, okay, appeal date is getting over, now what to do? I may store up to 1st July, but today is already 4th July. Again, I need not worry about portal crashing during the last days after. So let me pay that 10% and it's a free deposit. It's not actually going to anywhere else. And in case you win, obviously you will get back.
Sir,
If you lose, also they are going to realize the entire amount. You might as well play the
True.
thing by paying 10%.
sir, coming to the application fees, Lordship was saying that it is a nominal fee against your, but again, sir, the case I will win, I'll get back the money. Pre-deposit, I'll get back the refund because that is the confidence we have in our cases. But this fees is something which is going to hit us. I agree, but the only request would be when we are copycatting this GSTAT for most of the things, including best practices. GSTAT has a 500 rupees for an appeal.
1682.
Yes,
What
sir.
is 5,082 is 15% now. Actually, in the law, they should never give absolute figures. They should always say
Sir,
that 0.5.
There are cases where our fees are going to be, 25,000 each. And for each application also, if it is going to be the same 1 lakh, then it is hitting. If possible, we request Lordships to represent that it can be considerate. For 82,500, I can't say anything. A very logical answer. But that is really hitting hard so many people because 25,000 rupees. So many penalties are now. See, in this GST is a regime where we have at least 5 pages of order, which will carry only the notices having the penalties. There's that man, so many are there. So everybody has to pay the fee. And so that is one request I wanted to place before concluding. Sir, there is a special bench which has been constituted. Lord should be knowing. It's a very, very important thing I wanted to present before I take this opportunity. Sir, most of the cases, what we have filed or what we have burdened, I would use the word burden the High Court till date on a writ petition. Writ petition is something for 226 invocation for your fundamental violations. But often we have been using that forum till date across India only for very, very one small issue, missing the timeline of filing appeal before the first appellate authority. Sir, you have to consider that we are coming from a regime of 2017 it started, and thereafter this electronic migration is something which is very new to many of them. Not everybody can afford a very sophisticated consultant or an advocate. So there are so many people, and this has gone down to the traders. Central excise was at least disciplined because it was in a manufacturing and you are supposed to know or envision. But when GST has transgressed to the smallest traders with only 20 lakhs, at least in GST, Central excise, we had 1.5 crores of a SSI exemption. But here it is 20 lakhs. So in no time you will cross and you will become, but they will not be in a position to afford to first electronically, and talking about the 17s, 18s, 19s and 20s. Till COVID, we call it. That period, so many appeals were missed out and not able to be filed. And this communication also in electronic forum, like in portal or mail, has been missed out because in central excise, at least from the central government, from where I am reflecting upon, we used to get a speed post or with there will be an actual physical copy which you used to receive. But in state, it has not been, it is only uploaded. So a lot of issues, lot of cases have been filed on writ petitions at various courts. Now, courts have been giving variety of judgments, paid 10%, 20%, 30%, 50%, 100%. They have their own, they get irritated because their writ jurisdiction is being completely exploited. And I would say that it is not correct. Going to a writ court for asking them to extend the writ, the time period is something which is absolutely not correct. So courts get irritated and say 100%. 100% you pay. So now GSTAT was the beacon we were looking upon. Now it has come. There is a special bench which has been constituted, Lordships was knowing it, to consider whether the first appellate, wherever we have been, yes, constituted a special bench to consider this point that if I have missed the bus before the first appellate authority, whether that can constitute an appeal before the tribunal, where I can come and try to convince, the same way than a condemnation where you have a window of 3 months. Like that, if I have missed the bus before the first authority, I can come to the tribunal, not burden the courts, and argue my matter saying that why I could not file it. That is now taken cognizance. Though the special bench is constituted, definitely I know that all of the members will have a say in this, because all of your jurisprudence, your understanding, your compassion, everything will be taken cognizance before arriving at a decision, because of the national issue. From Coimbatore, we place a request. If such thing comes, please consider for the first year. Hereafter, no. I would only request for the initial formative years, if there has been a miss, and if it is, allow us to file an appeal before lordships, try to convince on why it has happened, take a proper judicious call, because as I said, this is the first confidence for the entire trade. So we will try to convince you. If you are not convinced, throw it. But give us an opportunity. Please take this as my last request. With this, I leave it to the podium. If any questions, I can answer. And thank you once again, sir, for an amazing presence and presentation. Thank you, sir.
Any questions? One or two?
There are cases where the state authority percolates time also. So it is really matter of dismissing the case. There are also set of cases. Like within the 30 days time limit, which they have the powers to condone. Without even hearing, they rejected in April 0. There are set of cases are there. So that can also be taken up and then decided.
Are you talking of
The state authority, first appellate authority.
state appellate authorities have dismissed cases?
The appeal filed after the 3 months time, but well within the 1 month time.
Yeah, okay. So
Without even hearing us.
So there is a disturbance, strong disturbance.
Sorry?
The mic is having a disturbance.
No. So he said within that 1 month also they have to.
No, so obviously those are cases where the tribunal will definitely hear, so long as you file the appeal, tribunal within time. That will be done. Then they will be obviously be heard.
Bunching of cases. No, those cases also can be bunched because it has to go back, because there is nothing on the merits of the case.
Yeah, okay, fine. So that we can note down.
Yeah.
Then you're talking about cases where the first appellate authority dismissed the appeal as time barred without even, which are filed within the 1 month condonable period.
Yes.
Without even giving a year.
Yes.
Yeah, okay. So we can examine that. We'll examine that. We will try to.
Okay. Thank you.
Sure.
Good evening, sir. Sir, there is one scenario in state where appeal order has been, first adjudication order has been received, and then we have filed a rectification request, and rectification request is rejected after some 6 or 7 months. Then we have original time for filing appeal is expired for the first order, and we have filed appeal application for the rectification against the rectification order, and the appellate authority has dismissed the case that we will only hear to the case, that is whether this rejection of rectification is correct or not, without going into the merits of the case. It is simply dismissed that it has no merits, that is, it is an error in law or error in facts of the case. It is simply dismissed. The case was dismissed, and we have filed against the rectification order. And there is a issue in the portal when we file a appeal on the rectification order. It is saying non-demand order. So we have simply paid 10% against DRC 03. That is through a procedural thing. We have paid a 10% of a pre-deposit for the non-demand order, and now it is got dismissed. Now, in this scenario, if we again go for this tribunal, whether it will be decided on only on the case of rectification or whether merits will be taken for the issue.
Okay, so this is a case where the an original order was passed.
Yes, sir.
Now, against that order, you filed a rectification.
Yes, sir.
Now, against an original order, there is a particular period for filing an appeal. So that's a 3-month period for filing an appeal.
But we have waited for the rectification order.
Correct. So, did you file your rectification request within the 3-month period?
Yes, sir.
Okay. So, wherever you filed a rectification or a request for rectification within the appealable period.
Okay, sir.
Okay, those are cases which the tribunal can consider.
Okay.
On this thing. But suppose you have filed the rectification request outside the appealable period.
No, it is not possible, sir, because system will not allow beyond 3 months to file a rectification application.
Okay, so these are cases which we can actually hear.
What he's asking is, against this rectification rejection, they have not got into the merits of the case. Whether this rectification application to be considered or not, they have rejected.
Yes, sir.
Now he wants to file an appeal on this point alone to the GSTAT.
Yes.
See, please always remember there are two things that can discuss
Yes.
here. One is that law procedural matters we can discuss. Judgmental matters we cannot sit and discuss, right? What I'm saying is, can be discussed on the bench cannot be discussed openly in a thing, because he may feel, I may feel. But still, I will give you an advice. Judgments are not given in meetings. Judgments are given in the court. So any judicial prediction that if you file an appeal, whether it will be considered or not.
Not. I'm asking about not consider or not. I'm asking whether to file against the original order or to file against this finally passed dismissal order.
So you can only come to us against as a second appellate authority. So
Yes, sir.
only on the first appellate authority order only you can give. Now
Okay.
you have first appellate authority order only on the rejection of the rectification only. You don't have it on the merits. So
Yes,
you can only come up on that. Now once that window gets opened up, who knows, the initial window also may get opened up.
Now, while filing, we will put up the grounds and all those things, and on what aspect we have to present before the GSTAT, whether about rejection of the rectification or with the merits.
Both you cover, no? First portion you cover about why they have rejected, why they have erred in rejecting,
Okay,
what
sir.
was the mistake which is apparent on record, however they are not considered, on that you argue.
Okay, sir.
Apart from the above, I would like to also mention about merits of the case, both you cover,
Okay,
and
sir.
you go to them.
Okay, sir.
Judiciously, bench will first listen to the order of first appellate authority, whether it is correct on them portion to reject the rectification or not.
Okay,
Suppose they pass an order remanding it or giving a decision depending upon the outcome, the first appellate
I
authority.
understand. I understand. Thank you, sir. Thank you,
Sir,
sir.
here I can only improvise upon what is the pre-deposit here. Because it is only a rejection of my ROM rectification. So what? There is no quantification. That is also he raised. He said that portal is saying no demand order or something. Like maybe another thing also could be cancellation of registration. There is no quantification to it. So what is the AR? I think 5,000.
Fee is 5,000. Pre-deposit is not.
Pre-deposit nothing. No. So there is no pre. So there also, because there is no demand, we'll pay the fee and we'll pay.
With that,
That's a very. Thank you.
with that, I'll close
So
the
5,000 we'll pay. That's irrespective of whether that original order is 10 crores, 100 crores, no. Because we are filing only on the rectification.
I mentioned in the slide also that, it is a non-demand cases, 5,000 court fee is there.
Court fee.
But I am not commenting anything on the pre-deposit because he is going to discuss not only rectification,
The other
other
one
case
also.
also. So we
Correct.
generally remain back on that.
200% watchful answer. Logic rightly says, because you are going to argue the original case also, I am not commenting on the pre-deposit.
These are bench decisions.
Correct.
Bench decisions cannot
We
be
file
taken.
it and then decide there and there. It is a judgment, not a opinion. Correct, sir.
Excellent session with you. A lot of questions from our members are there, those who have not attended also. Compile all the questions. And I think as
I'll filter it,
Ajay
sir.
rightly said,
I'll filter it.
requires a day for you to
I'll send it.
something.
I will send it to
And one small question, sir, maybe administrative thing, but still, one judicial member has not been appointed yet. Will it cause any delay in the process of this thing, or the 50 lakhs and above will not be taken on only on rotation or something? Just wanted to
He has
know as a
mentioned.
final
You have
question.
mentioned.
Yeah, so out of 4 judicial members in Tamil Nadu,
Okay.
only 1 judicial member is there. Now he has to, the vice president, he has to go by turns to each bench. So normally, if judicial members have been appointed everywhere, then we could have heard all 50, more than 50 lakh cases every day. But now we are forced to hear 2 days in Chennai, 1 day in Coimbatore, and 1 day in Mathew.
And we can represent from our chamber for the speedy appointment or something.
That will do.
We have
Beneficial.
to represent to
But we should.
The central government,
government or
central government is supposed to appoint, it all depends on how much lobby you can exercise to appoint as soon as possible. We'll be very happy with judicial
Yes,
members to be appointed.
64 is the total judicial members.
Judicial is from
Judicial
center. Judicial is from center.
Judicial is from center.
But you have to understand that yes, there will be a problem because it's humanly not possible to hold 50 lakh more cases every day. So there will be a delay. But we will try to mitigate it as much as possible. That is all I can assure you right now.
Thank you. We will.
Consider.
That should be the my personal.
I know, perfectly correct. But even in high courts also, if defect is raised, they don't take when you attempted to file. They only said when the defect is cured, when you get a civil appeal number or writ petition number. Same manner here also, the
So
law.
they ask for a COD.
COD, we file
Continuous of delay they will ask.
because
For a
Here also you
rectification,
can ask continuous of delay.
we can.
But 3 months period also gets over. It's
exactly.
risky.
My intention is correct. I have paid the pre-deposit. I have paid everything.
Date of original file.
Original filing should be.
Or by pre-deposit.
Correct. So the long as we deposit is fine.
Yes. Pre-deposit, yes.
Is a
You have
real
insisted.
proof. Pre-deposit
That
and
is the
court
proof.
is the best.
Yes, that's. Thank you, Milad. Perfect.
Respected guest speakers, Shri M. Mathew Jolly, Honorable Member, GSTAT, Shri S.K. Rahman, Honorable Member, GSTAT, Mr. S. Jaikumar, Founder and Country Head, Swami Associates, and also our mentor and the GST consultant for almost from the day it started, members of the chamber and the participants, good evening to all of you. It is my privilege to propose the vote of thanks on behalf of our chamber. At the outset, I express our heartfelt gratitude to Shri M. Mathew Jolly and Shri S.K. Rahman sir for sharing the invaluable knowledge and practical insights for the functioning of the GST Appellate Tribunal and evolving GST disputes resolution mechanism. Sir, you have won our hearts and confidence for sure. It has been a privilege to be here to hear your address today, and we will make it a success for sure. I place on record our sincere appreciations to Shri S. Jaikumar sir, founder and country head, Swami Associates, for his excellent contribution in the organizing this program. Without him, this wouldn't have happened. Thank you very much, sir. It was really helpful for us for moderating the session with a great clarity and professionalism, and for his continued guidance and support for our chamber in GST-related initiations. My sincere thanks to our president for giving us this opportunity in knowledge sharing and programs to benefit our members and the business community. I extend my gratitude to all the office bearers, governing council members, and for the enthusiastic participation and continued support towards the activities of the chamber. A special word of thanks to all the participants for your active involvement, thought-provoking questions, and keen interest which made the today's session truly inspiring and a successful one. With these words, I once again cover our sincere appreciation to everyone who contributed to the success of today's GSTAT awareness and outreach program. Thank you. Thank you once again.